in Chattanooga, Tennessee. He's been an attorney for 36 years of trial and appellate practice before all courts of Tennessee, Georgia, United States District Courts, and federal courts of appeal for the 5th, 6th, and 11th circuits. The focus of his practice has been civil litigation and appeals. He enjoys Martindale-Hubbell's highest rating for legal ability and ethical conduct. Mr. Berry has previously served on investigating committees for the Tennessee Board of Law Examiners and currently serves on various committees of the Chattanooga Bar Association. He has been an invited speaker on various topics of civil litigation for the National Business Institute and the Federation of Defense and Corporate Counsel. Mr. Berry has tried approximately 100 civil cases to verdict and handled numerous reported cases on appeal to state and federal appellate courts. Thank you for being here.
Thank you. Let me see if this works. Are y'all hearing me okay? Okay. Well, let me say, after all that fauntleroy, I am honored and flattered beyond measure to be here to speak to y'all today. And as I was riding up here today to talk to you, it occurred to me somewhere around Monteagle Mountain, I came from Chattanooga, that in my 34 or 5 years of private law practice, every time I got a court reporter to show up and listen to me talk, I had to pay a bill. But you know what? It occurred to me today, I've now got maybe 150 or 200 of them that have to sit here and listen to me talk for nothing. And to boot, I got lunch out of the deal. So thank you again for having me. I will tell you that as a lead-in to my first topic, I had thought about telling y'all a little funny or a little anecdote that might give us some levity before I start. But knowing the innocence and sensitivity of this room full of ladies and gentlemen, I thought it would be a good idea for me to check on that funny or that joke with your esteemed president, Ms. Wilson, before I launched it for your ears. I regret to tell you that that was censored. So, Ms. Wilson, being the bastion of morality and good morals that keeps as many of y'all as she can straight, I will tell you, you don't get my joke. But anyway, well, yeah, but I understand she's still the president. But anyway, joke aside, the first thing I'll have on my topics is dealing with the engagement. And let me tell you, before I delve into this, that what I'm getting ready to discuss with you will not have application in most of your cases. I take it that most of you in here have established legal court reporting practices, that you know your customers, you know the lawyers that you deal with, you know whether they are persons that can be trusted to pay your bill and honor your invoices and things of that nature. The purpose of what I'm going to talk to you about today is when you get that new client or that new business that you're not familiar with. You don't know the lawyer, maybe it's an out-of-state lawyer, maybe it's a lawyer you're not familiar with, and you can't be certain about your invoice and whether it might be honored or not. The other circumstance, regrettable as it is, and I think we all know this, there are some lawyers, law firms that may, for whatever reason, have reputations for not paying their bills in a timely manner, if at all. So these situations that I'm talking to you about now, I'm trying to give you some ideas about how, when you're confronted with one of those, what I'll call high-risk situations, how you might protect yourself and your invoice. I'm going to give you three scenarios here that I think usually occur. Let's suppose first scenario is with regard to a deposition. Either the lawyer or the lawyer's secretary or the lawyer's paralegal or somebody calls and says, hello, Ms. Court Reporter, I represent XYZ, John Doe represents ABC. We've agreed to a deposition of ABC's representative at such and such time, at such and such place. We want you to cover. Okay? That's a deposition scenario. Next thing that may happen to you is you may have a transcript order. Maybe you took down a temporary restraining order hearing, maybe you took down an APL hearing or something like that, and the call comes in from the lawyer or from his paralegal or from somebody saying, my notes show that we split your appearance at the temporary hearing restraining order, and my client wants a transcript of the testimony of Mr. He Say, Mrs. She Say, and Chancellor Who Say. Please write it up, okay? Or the third scenario is the appellate transcript order. Lawyer writes you, calls you, emails you, and says like this: my client has decided to appeal. He wants you to get started on the transcript. A copy of the notice of appeal is enclosed. Okay? Now those are three scenarios. Now, in each case, let's suppose you do the work required, you turn out the product, you deliver it to the attorney, and you don't get paid. And then yet again, still you don't get paid. And then yet again, still you don't get paid. I wonder what the vote would be in this room. How many of you think you have a 100% chance of recovering that money against that lawyer that hired you? Anybody? All right, how many think you got a 50% chance of recovering that money from that lawyer that hired you? Maybe half of you. Let me tell you, under those three scenarios I just gave you, I'm giving you less than 10% of being able to recover against the lawyer or the lawyer's firm that hired you. Now you say, well, why is that? Well, here's the problem. In Tennessee, a lawyer has by statute the power to engage on behalf of the lawyer's client services that the client may need in the course of that representation. Amongst those services that the lawyer engages many times are court reporters. Okay? So what the lawyer says when confronted with your invoice, he or she or the firm may say, wait a minute, we were only acting as agent for our client whenever we hired you. You can't sue us directly because all we were doing was acting as agent for our client. You're going to have to get your money from the client. Not a very desirable kettle of fish most of the time. Now, how do you get around that? How do you avoid that? You need to do the best you can to make sure that the lawyer or the law firm personally accepts the obligation to pay for your services and that your services are of benefit personally to that lawyer and that lawyer's prosecution of that case. An example, should a lawyer write you a letter that said, I am engaging you to provide me with a transcript for my use in this case, I think you got him. You're not going to get me letters like that from lawyers, I tell you. What you might get is something more like this. On behalf of my client, XYZ, your services are being engaged to provide a transcript for my client. That's what you might get if you get anything at all. You'll notice in that circumstance, the whole focus is, you're doing this for my client. You're doing this for my client. You're doing this for my client. Okay. How do you fix that? Well, I have the suggestion that if it is new business or business that you have uncertainty about in the context of getting paid for doing the work, that you send yourself or on behalf of the agency that you manage or own a letter back to whoever the lawyer is. And I suggest to you this language. We're going to say we're writing back to a lawyer I'll refer to as Mr. Stiff You, okay? All right. So we write back to Mr. Stiff You as follows. Thank you for selecting true and honest court reporters for, and then describe the services, whatever they are. And then say, we are accepting this assignment upon the following understanding between you individually and true and honest. We consider the order you have placed to have been placed by you personally, and we are looking to you primarily for payment of our invoice for services because you will have the benefit of our work in the case. And then you get nice to them and you say, we are pleased to have your business, but we feel it's necessary to have your personal assurance for payment for work done on this assignment. If for any reason this is not acceptable to you, please let us know promptly. I suggest to you that if you will use that language or something similar to it before you go to that engagement, or as timely as you can do it, you will have far, far better chances of coming out okay if the invoice goes south with the client. Okay? There is a case, probably the best case I know of, that addresses this subject is the O'Brien versus Hedman case. It's a case out of Knoxville, older case, 1984. And in that case, what happened is that the court reporter had done work and the client hadn't paid it and the lawyer hadn't paid it. And they went to trial, and at trial the testimony by the lawyer was that he said that he told the court reporter that he'd try to get his money from the court reporter, but if he couldn't get the money, the lawyer would try to pay it. The lawyer also admitted that the transcript at issue for which the invoice was due was of benefit to him or her. I don't recall if it was a man or woman lawyer that was getting sued, but anyway, it was a benefit to the lawyer in preparation for trial. On those facts, the personal benefit to the lawyer, on those facts, the court held that the lawyer owed the bill. That doesn't mean the client didn't know it as well, but trying to chase down clients of lawyers, I think, is sometimes a little bit more than what you ladies and gentlemen want to spend your time doing. So those are my suggestions to you about that. The next thing I wanted to talk about is a topic I have used poetic license a little bit, and I refer to this problem as the hot potato transcript. So we have this situation. What happens when a lawyer that I'll refer to as Chipper Cheap, and we know that Chipper Cheap is out there. Mr. Cheap, do you want to split? Well, I don't want me to talk to my client. Oh no. Can I get back to you on that? I've seen it happen. Y'all seen it happen. It happens all the time. But anyway, old Chipper never does agree to split your per diem with you at a hearing. And lo and behold, sure enough, down the road, Chipper finds out, damn, I really need that transcript. Serves him right, but anyway, that's what happens. So what do you do whenever Chipper calls you up and says, hey, you know, true and honest, I'm really sorry about this. You know, I meant to split appearance with you, but, you know, I know I didn't. But I need that transcript. What do you do? What do you do with Chipper when he calls you and says that? What do you do? Do you turn him down? Out of hand? Say, sorry about that, Chipper. Can't have it? Is that what you do? All right. Let me tell you the law about that. Okay? As best I know it. There are two lines of authority in Tennessee on that subject. The first indicates that a party that did not agree to split the court reporter's appearance fee cannot obtain a copy without the agreement of the engaging party and the court reporter himself or herself. Okay? There are a bunch of cases in Tennessee that support that view. Perhaps the best case is a Randolph case, and I will quote from that case because I think it sums it up. A party who does not join in the engagement and payment of a stenographer has no contract right to require the stenographer to transcribe the record, which is therefore unavailable unless and until made available to him on terms satisfactory to the stenographer and to the party who engaged the stenographer. Okay? I think that is the majority view in this state on that issue. And there's a danger here bound up in this topic we're discussing. And that danger is what happens if you have taken a transcript at the instance of a party and been paid for the appearance and paid for the transcript, and then up shows another party and says, I'll buy that transcript from you. I know it only cost you or the other party $1,000, but I need it so bad, I'll give you $5,000 for it. Okay? All right? Add up the ante a bit, didn't it? Add up the ante a bit. Well, this Automax case says that, yeah, you can do that. You can sell that transcript to that party, and the Automax case involved a proceeding in General Sessions Court where the testimony was taken down in General Sessions Court, and one party paid the court reporter for the per diem, the other didn't. And then the party that decided later they wanted the transcript approached the court reporter and said, I want a transcript of this General Sessions trial. And the reporter sold it to them. And the party that had hired the court reporter went to court and said, Judge, this isn't fair. This other party, even though this other party got it from the court reporter, and I don't contest that I don't say it's inaccurate, it's just not fair that this other party didn't participate in the cost of it and now gets it. Well, the court in Automax said, I'm sorry, your remedy is against the court reporter for selling it. The remedy is not exclusion of the transcript, because this party maybe unlawfully, but bought it from the court reporter and can't be prohibited from using it. However, the court was careful to say, if Automax, who was the party that had originally ordered the transcript, if Automax disagrees with the court reporter's actions in selling a copy of the transcript, that is a dispute between Automax and the court reporter. I would be willing to bet you, although I did not follow that case, I'd be willing to bet you that there could well have been litigation filed against the court reporter for doing that. So the lesson is, don't do that. Don't do that. Okay? There is another line of authority in Tennessee that seems to have limited application to me, and that had to do with a situation where you've got two parties who agree to split the per diem of a court reporter, but a third party who's involved in the case does not. In other words, defendant A and B say, yeah, we'll split. And defendant C or plaintiff, whoever it is, the other party says, no, we ain't splitting. Okay? Now, if you have that circumstance, the law seems to be, if either one of the two that agreed to split with you, or split amongst themselves, if either one of them agrees that you can release that transcript, that's sufficient, because each has an equal right to it and its control. All right? But in each circumstance, you're still going to be entitled to the copy cost or whatever fee that you would reasonably charge for furnishing that transcript to this extra party who's now asking for it. Okay? I guess the lesson is, if you get in one of these tight spots where you do, and you can't, no party seem to be able to agree, and you know you're having to take the position, well, I'm sorry, I can't sell you that, I can't let you have that, and the lawyer wanting it, is getting kind of horsey or whatever. My suggestion would be that you say to that lawyer who wants it, look, Mr. Lawyer, or Miss Lawyer, why don't you go up to the court involved here and ask for some instructions, file a motion for instructions with the court, and whatever the court says I ought to do about this, I'll do. That's if it gets to loggerheads, I think that is the most prudent course of action for you to do. And if the lawyer that wants the transcript won't do that, then you're going to have to decide whether or not you want to spend the money to hire a lawyer of your own for advice about that, because these are changing, fluid circumstances, and I can't begin to give you all the turns and machinations that might be found in those things. But the best rule is, don't sell it without permission from at least one, and hopefully all parties who did in fact engage you for that work. Okay? Now there is, I guess, a caveat to that, and it does have to do with depositions as opposed to transcripts of evidence. In the deposition context, rarely is it that the witness ever agrees to pay you anything or engages you or anything else. That witness is usually there because the lawyers concerned have gotten him there or gotten her there. Now, if that witness, or any party for that matter, comes to you long after the deposition is prepared and sent out to whoever it was that ordered it, I want a copy of my deposition, you ain't got any choice. You've got to sell that witness a copy of his deposition. Or her deposition. You've got to sell it. You can sell it for the reasonable price you would charge anybody else for a copy. but a witness or a party has every right to buy a copy of that witness or party's own deposition. Not anybody else's, but theirs. Okay? Okay. Trying to watch my time here. The next thing I would like to talk about are some of the similarities and some of the differences between the Tennessee rules of civil procedure and those found in the federal rules of civil procedure. Perhaps the biggest difference between the Tennessee rules of civil procedure and the federal rules of civil procedure has to do with, well, before I go into that, I think everybody in this room knows that no longer, if you're a licensed court reporter, no longer do you have to be a notary. If you're a licensed court reporter, you could administer the oath and go right on. That used to be a part of the rule in Tennessee. It's not anymore. Y'all know that. But if anybody doesn't, you don't have to worry about it because you don't have to be a notary anymore. But anyway, back to this what I perceive as a major difference between the federal rules of civil procedure and the Tennessee rules of civil procedure. And it has to do with the qualifications of the officer. Tennessee has now amended its Rule 29 as to qualifications of the officer to essentially default the analysis of the qualifications or disqualifications of the officer over to what I think I've heard referred to today as the anti-contracting law, the section which says persons before whom depositions can be taken. Y'all probably well know that citation. But Federal Rule of Civil Procedure 29 in Tennessee defaults you to that statute. And that's where you go to decide in Tennessee about the qualifications or the disqualification of a person to serve as a court reporter at a deposition. Now, the federal rules of civil procedure have not been so amended and do not so provide. And I think that's important to those of you that do very much or take very many depositions in actions that are pending in United States District Court on the civil side of the case. I'm not talking about criminals. I'm talking about civil depositions and civil cases taken before federal district courts. You probably know, if you don't, I will tell you that a case in federal court, if it's in diversity jurisdiction, the substantive law of Tennessee would apply to that controversy. Those questions would be like, what is negligence? Or did this person breach the contract? Substantive law of Tennessee in a diversity case would, of course, be applied in that federal action. However, federal court preserves its own rules of procedure that must be observed in cases in federal court. Most importantly, I think for your purposes, is the provisions of Federal Rule of Civil Procedure number 28D. And what that says is, a deposition must not be taken before a person who is any party's relative, employee, attorney, or related to or employed by any party's attorney, or who is financially interested in the action. Ladies and gentlemen, there is no provision in federal law to stipulate away that federal disqualification that I'm aware of. Now, in state court, I grant you, apparently the way that anti-contract statute is read under the appropriate circumstances, lawyers can stipulate to anything. Stipulate anybody can take it. But I suggest to you that in federal court, if you believe that you are a court reporter that has a disqualification, whether it be a disqualification by what I've heard referred to as contracting, whether it be a disqualification by having financial interest in the case, whatever it might be, I think you better be careful about Federal Rule 28 in federal practice, because I don't think that you can stipulate away the federal disqualifications that remain in effect. Whenever a federal court or federal legislation says a deposition must not be taken, that's what they mean. So I point that distinction out to you. Some of the other differences between state civil practice and federal civil practice, the state practice makes the default of the witness's signature operate what I would call in favor of the witness. In other words, if the witness whose deposition you are taking does not affirmatively reserve signature, does not affirmatively waive signature in that deposition, then that witness's signature is required. I know that routinely parties and lawyers for parties waive signature, and that's fine. But if that witness's signature is not waived, then Tennessee practice requires that witness be given 30 days after that deposition is prepared to read and sign. And if that witness does not do so within 30 days, then of course the reporter is at liberty to go ahead and file the deposition with the notation that the witness was notified and did not appear and read and sign. But note that the federal rule is different as to depositions. The federal rule, I think the default provision runs, I guess one would say, in favor of the court reporter or in favor of not having to get a signature on a deposition. Under the federal rule, unless the witness says before the conclusion of the deposition on the record, I want to read and sign, then that witness has lost that witness's, quote, right to read and sign. In other words, the request to read and sign federally must be articulated by the witness during the course of the deposition. You note in state court, it's just the opposite. If nothing is said about it at all, the right to read and sign is preserved. So that may be a distinction that has some importance to you if you do much federal work. Another thing or two that I find interesting about distinctions between federal civil procedure. Can y'all still hear me? Federal civil procedure and state civil procedure is that federally, the reporter concerned, the officer is what the statute says, but we know that means reporter. The officer is supposed to announce at the end of the deposition the number of exhibits there are and who is going to keep custody of which ones, and that must be done in the presence of all parties. That's not required under state practice, but there is a federal rule of civil procedure that says one of the duties that falls to the court reporter in a federal deposition is to make an announcement for the record about how many exhibits we got, who's keeping what. Mr. So-and-so is keeping 1 through 9, Mr. So-and-so is keeping the rest of them, and the court reporter is keeping whatever the court reporter is keeping. Okay? There is also an interesting provision at Rule 30F in the federal rules, which has to do with a party who brings exhibits to a deposition that are sought to be marked and entered. If a party who produces an exhibit wishes to keep the original of that exhibit, that party has two options. That party may either offer copies to be marked and used as originals, provided all parties are given opportunity to compare them with the originals, or give all parties the opportunity to inspect and copy the original exhibits after they are marked, and then retain the original exhibits. Okay. The state rules give no specific instruction about the retention of the officer's notes. The state rules don't give any instruction as to how long a reporter might have to keep the notes of a deposition. And the state rules don't even say that the reporter has to retain notes. I know we all do it, but the state rules don't say that you have to. But the federal rules require that the officer retain notes of the deposition. But it doesn't give, the federal rule doesn't tell you how long. It just says Rule 30, Rule 30G just says that the officer shall retain the notes of the deposition. All right, let's talk a little bit now about appeals. As I go through this, I'm eliminating some things I would talk about because I know we have some time constraints. We got started late, so I'm trying to make my part of this end at about 3:15. I think that's what's supposed to happen. So that's what I'm going to try to do. Tennessee Rule of Appellate Procedure, sometimes fondly referred to by lawyers as the TRAP, T-R-A-P. And there are some traps in it. Traps in it for lawyers and some for reporters as well. Probably more for lawyers. You ought to be glad of that. But let me talk to you about that some. Let me tell you what the law requires about the transcript in a Tennessee appeal of a civil nature. First of all, the transcript of the evidence shall clearly indicate and identify any exhibit offered in evidence and whether that exhibit was received or rejected. The transcript shall be filed within 60 days of the filing of the notice of appeal. With regard to corrections of the record, if a dispute arises regarding whether the record accurately describes what occurred, the trial court judge settles that. In extraordinary circumstances, the appellate court can direct the preparation of a supplemental record, but that is rare. Usually if there's a dispute about what some witness said or what some exhibit was or whatever it may be, the judge that tried that case is going to have to say, regardless of what your notes say. It's that simple. With regard to exhibits, your exhibits are required to be compiled in numerical order in a volume or volumes separate from the transcript. That volume of exhibits must contain an index listing all exhibits and whether they were admitted or excluded. The form of the transcript is probably well known to you, but just in order to cover that base, that transcript must be on white, unglazed paper, preferably recycled. Yeah. The paper must be 8.5 by 11 inches, in type not smaller than 11 point, double spaced except for quoted matter, and typed matter must be confined to 6.5 by 9.5 inches, e.g. a 1-inch margin at top and bottom and 3/4-inch margin left and right. So that's how it's supposed to look. The next thing is if there are documents or exhibits that were received under seal in the trial court, they shall be filed in the appellate record as directed by the trial court order which placed them under seal when the transcript or record is filed. Now, I had this come up a while back. Many times when the trial court judge says, we'll file these under seal or this will be filed under seal, the trial judge doesn't give any direction about what, although they were filed under seal, doesn't give any direction as in his order or her order as about how that should be handled when the record is being assembled to go up on appeal. My suggestion to you is if you're confronted with that problem, that you have a conversation with two people. You have conversation with the lawyer whose client's records were the ones that were filed under seal, because that's the party that's got the interest in them continuing to be held under seal. And you might have a conversation with the circuit court clerk or the clerk and master about how that has been handled in past in that particular venue. So if you don't have direction from the chancellor or the circuit judge who directed some records that are in the record or exhibits in the record to be filed under seal, you probably need to get some direction from the lawyer concerned or from the clerk or maybe both. And usually what will happen is somebody will go back to the trial judge and say, Judge, you didn't say what you wanted done about this. We're now on appeal. Will you please give us a supplemental order? Most courts are very willing to do that. But my point is, just don't stick them in the record without some direction. I would mention to you that trial court clerks across this state seem to have varying sets of rules about how they think that the transcripts should be bound, especially if you've got large transcripts, numbers of pages, hundreds of pages. I know that some trial court clerks want transcripts volumes to be separated at 150 pages. Others seem to have special rules about the number of exhibits that might go in a given volume of exhibits. A good suggestion is if you don't have familiarity with how the particular trial court clerk, whether it be the clerk and master or the circuit court clerk, wants those matters handled, and you have a good-sized piece of transcript or a good number of exhibits, you might want to go by there and talk to whoever it is, just a moment, and talk to whoever it is that deals with that within that office. Who gets there? In other words, which one on the staff will get this appellate record ready to go up and be filed at the Court of Appeals? Someone had a question. Well, it depends on the custom. I know, for example, in Hamilton County, many times when a trial concludes, the court reporter retains those exhibits. That's not an unusual thing. Yes? That's right. I'm reading to you from Rule TRAP 24A, which says, the transcript of the evidence shall clearly indicate and identify any exhibit offered in evidence and whether it was received or rejected. That's in the transcript, okay? But then you go over to the exhibit section, which is section D of the same rule, 24, and it says, exhibits shall be compiled in numerical order in a volume or volumes separate from the transcript. The volume of exhibits must contain an index listing all exhibits and whether they were admitted or excluded. That's what Rule TRAP 25D says. Okay. Yes? Many times I have had that occur. I don't know that I agree with that. I think you're right. I think the rules of the Court of Appeals or Supreme Court probably trump that. But what I'm saying is, if you're trying to get a record out and you've got some clerk in some county, I've had it happen where, oh, this is not right, we can't take this. And you get an argument with them about it, and it's just not worth the hassle. I mean, that's just a bit of practical advice. Okay? I know, and what I'm telling you is the advice I'm giving you on this score is purely practical to make your life a little easier when you're confronted with a clerk that does this and says, you're going to do it my way. You know? So, Anybody else have something? Okay. Now, I do know that, and rightly so, each of you in here that prepare transcripts and file them or have them filed are jealous of that product and want to get paid for that product, and I don't blame you. It is your work. It's your livelihood. But I got to tell you something about the appellate practice in Tennessee. Once the transcript is filed, regardless of whether or not anybody split per diem or anybody paid a nickel, or some party paid a nickel for that transcript, the parties can agree that the entire transcript be retained by the trial court clerk until the appellate clerk orders the record sent forward. That means that Chipper Cheap can run up there to the courthouse and obtain what he would not otherwise have been entitled to. Another troublesome part of this is that even if the parties don't agree to have the record retained at the trial court level, as is permissible until the Court of Appeals calls for it, any party to that appeal can ask the clerk of the Court of Appeals to send that party the record and the transcript in order that that party can prepare what's referred to as the appellate papers. So Chipper gets over a little bit there, because once that appeal is up there and the appellate record is filed, the appellate court clerk doesn't have any choice but to release that record to a party to the appeal, regardless of whether that party paid anything for that transcript or not. So I know that may be something that would give me heartburn if I were in your shoes, but it is the law right now, and I don't see that there's much likelihood of it being changed. Yes, ma'am.
That also applies if a record has been filed in your local clerk's office, county, and chancery court, like a doctor's deposition or anything that's filed with the clerk's office, then it becomes a matter of public record, and they can sell it to you.
That's why when I file my doctor's depositions or whatever it is that I file, I don't file the whole thing. I file only that 1, 2 page, 3, 4 pages that I need. That supports my position, and I don't give anybody else that didn't pay the freight their chance to use that beyond what I have used it for. I didn't hear you. I was asked to talk to y'all about things that I think might be helpful to you. And every lawyer might conduct himself or herself differently in this context, but I tell you how I do it, because I think I've tried to do it the way it's fair. And others may disagree with me on that subject, but that's my opinion. Yes, sir.
So how do we as a group stop that and insurance companies have 4 lawyers that say,
I'm having a hard time hearing you. Let me walk over closer to you.
how do we as a group court orders stop copying? Also insurance companies do it. They'll have 4 lawyers there that say, y'all just copy and share it. Insurance companies instruct the lawyers to do that. So how do we, as a group, stop that?
Well, let me address that this way. If I pay a court reporter for a copy of a deposition, I own that copy. I have paid for that copy. If I want to copy it and let my client read it, I can do that. If my client, once he gets it from me, wants to copy it and let Aunt Millie read it, he can. But you got to recall, that's a copy. That deposition that you're talking about is a copy. I'd be willing to bet you it doesn't have an original certificate on it.
No, I'm talking about original stuff. People going to the clerk's office and copying. I mean, how do we put a stop to that?
If somebody files it, it's a public record. Unless it's filed under seal or under some protective order, if it's filed in the circuit court clerk's office, and I want to go up there and pay whatever the clerk charges me to obtain those copies, I mean, there's the public records law would prohibit the clerk from not letting me do that. I think when you start paying, well, I don't know, I don't know what the economics are. I don't know how it works out. But I can tell you that if it gets filed in circuit court or chancery court or a court of record and somebody wants to go pay for copies, they can do that. There's nothing I know of, absent some legislation of some kind, that would stop that. Excuse me. A little dry here. Okay. Let's talk about, I see I've got about 14 minutes here left. I didn't hear you. Well, you censored my joke. I guess so. Yes, ma'am. I can tell you what the law is. No. The law defaults read and sign to a witness's deposition if nothing is said about it on the record. You go, you take the deposition of Joe Blow, witness is finished, gets up and leaves, and nobody says anything about signature or the waiver thereof. Joe Blow, under state law, is entitled to read and sign that deposition. State law. Well, if it doesn't, I'm not telling you how to get it in the record right now. But what I'm telling you is, if it does not affirmatively appear in a state proceeding, if it does not affirmatively appear, that witness has waived signature. By default, signature is preserved, and that witness has the right to read and sign. Okay? In federal, it's exactly the opposite. If nothing's said about it during the deposition, that signature is waived. I think you're right.
So does that mean the court reporter in state, the state deposition would automatically be a read and sign?
If there's nothing in the record that indicates the witness has waived signature, that is, under state law, a read and sign deposition. I do not think it improper for the court reporter to say at the conclusion, Mr. Witness, is this a read and sign? Okay? That you're not giving that person any advice. You're just saying, is this a read and sign? If a witness, whatever the witness says, then you can say signature waived if witness says signature waived. But if he doesn't or doesn't give you an answer, then it's a read and sign. I would like to think most lawyers would want, to not have that situation arise. I always try to tend to it whenever I'm dealing with witnesses, unless they really want it that way. Yes?
If nothing's said in state court, is it limited by 30 days?
Yes, yes.
They have 30 days to come back.
Yeah.
If they want to redesign minutes.
Yeah, but they have to be, if they don't waive it, they've got to be notified the deposition is ready. They've got to be given an opportunity to read and sign it. And they've got 30 days from that opportunity to read and sign to read and sign. And, what? I believe it's going to be under Tennessee law. I believe it's going to be yours. Actually, whose it is whoever it is wants the testimony of that witness. The lawyer that wants the testimony of that witness is going to tend to that probably. I mean, think about it. Right? And most depositions that I have been in, that's made pretty clear. If it's a witness that's appearing perhaps on behalf of one side or the other, many times the court reporter will ask the lawyer on whose behalf the witness appeared, shall I send it to you for transmission to him, or what are we going to do here? And that gets on the record. But I'm saying to you that Tennessee defaults to read and sign. Federal law defaults to waiver. Okay? Well, that witness has got to have, in state proceedings, that witness has to have the opportunity to read and sign. If there's nothing on the record. Yes, he does. He or she does.
So if he doesn't want to read and sign,
Simple, very simple. Witness comes to a deposition. Okay, where was I here? Something about my joke got censored. Where was this? Let's see. Oh yeah. All right. Yes. Okay. Let me give it to you. Oh, another thing I want to give you too. Let me give you the rule number. First of all. That's going to be Rule 30, Tennessee Rule of Civil Procedure, Rule 30C. And while I'm on that subject, I have no interest, no financial interest of any kind or otherwise with West or West products. But if you want to obtain copies, not copies, but literature having to do with these Tennessee rules of procedure and Tennessee rules of appellate procedure and federal rules of civil procedure, I have a website here that I'll furnish to anybody that wants it, where you can go. It's a pretty good set. It's a 3-volume set, and it's paper bound. They get $180 for it, but it's got everything you'd ever need in it as far as these rules are concerned. I don't know if copyright law allows me to announce that website to you or not, where you can get these things if you want them, but if you'd like it, I can probably give it to you privately after I'm finished here today if you want it. Okay, let's talk about it has come up, I'm told, about, and this may be a sore subject, I don't know, but it has come up about production and what constitutes production and personal supervision in connection with court reporting practice in Tennessee. Well, of course, we have the rule. It's a Tennessee board rule, and it essentially says that the transcript shall be produced through the personal supervision and or effort of the court reporter or both. That's the substance of it. And so one wonders, well, what amounts to personal production, personal supervision, such as would obey the mandate of that rule. Now, I know that I hire secretaries, paralegals, and all manner of support personnel, and most lawyers do, to get their final work product ready. My client hires me to dictate a brief in support of something, and I sit down, I go to the books, I hammer out the language, and I dictate it. It goes to my secretary, she types it, she sends it back to me, I look at it, I may make corrections, and ask parts of it to be redone. So I understand that your business is such that many of you use, I think you might call them scopists or proofreaders or some term for folks that assist you in trying to get a transcript ready to be in final form. And I would say to you, I do not think there's anything wrong with the use of folks like that to help you get your transcripts in what I'll refer to as final form. I think there is a real serious problem if, after you've used these various support people or support personnel, that you don't see yourself that final product that's going to bear your signature and or your electronic approval and or your, I think you have to put your license number on transcripts as well now. I'm suggesting to you that if you don't lay your personal eyes on whatever that transcript looks like when it is in final form, and I don't care who put it in final form, but if you have not looked at it and cannot adopt it after it is in final form, completely final form, I don't think you can affix your signature to it or your stamp of approval on it. I am told that there may be situations where a court reporter simply sends off some electronic disk or something and sends it to a scopist or some other third-party person, I don't know who all, but sends it to somebody else. And accompanying that is a certification page that the reporter includes with that submission and leaves it to whoever's going to produce the final form to just stick that page to it. I submit to you that is a dangerous, dangerous, dangerous practice. I do not think that it complies with the personal production supervision requirement of your board rules. I'm not suggesting to you that you can't use scopists and you can't use proofreaders and you can't use typists. You'd never get anything done if you didn't. I know that. I wouldn't either. But when that final product goes out the door, I think you have to have seen it in that final form before you affix your John Henry and give it its official character as being what it purports to be. Okay. Well, I see that I have now come to the end of my time. I will entertain questions if time permits. I guess it may. I don't know. Yes, ma'am. Yes, ma'am. Well, again, like we said, we temper this with sound business judgment. If it's the secretary of a lawyer that you do business with or a firm you do business with, you have no reason to worry about whether or not you're going to get paid. No, I wouldn't go there, okay? What I was trying to help you maybe avoid is it's the new client or the troublesome lawyer or the troublesome law firm where invoices are concerned. If you have a good business relationship with people, you don't want to spoil that by writing them some, letter of that kind. Maybe I didn't make that clear when I was introducing that topic, but I gave that to you to kind of protect you when you're getting new business and you don't want to turn it down, but you ain't too sure about it. Okay? Yes?
Along that same line, what happens when you show up to a court proceeding hired by a loyal customer, and then you ask the other side, do you want to split my per diem? And there's no time for a letter to be sent for to say, yes, I'm going to pay it. How do you handle that?
Well, I really think you just got to take the risk on that. I don't think there's a way to fix that. I'm talking about somebody that stiffs you for a $400 or $500, $600 transcript or a $400 or $500 deposition. I don't know what y'all get for splitting per diem these days, $7,500. I don't know what it is, don't care. But I understand unless there's a transcript order, it's not a lot of money, And I can't give you a solution to that problem. Yeah, I guess you just trust the guy. Or you write him a letter thereafter and say, you indicated you were going to split, and then you send him a bill, or her a bill, or the firm a bill, and kind of wait it out and see what happens, for their part. If they don't order a copy, you may well be stuck with your per diem loss. I can't help you with that. That's just a risk of the business. Happens to me all the time on clients that don't pay me. Yeah. Oh, yeah? In order to get payment? I don't see a thing wrong with that. I don't see a thing wrong with that. Yes? I'm not. Yes? Ma'am? I'm having a hard time hearing you, and I know they are. Let me see if I can get a microphone to you. I don't know if any of these are carry around. Yes, I think that's appropriate. Yes, I think that's appropriate, and there's nothing wrong with that. Yes, ma'am. The question was if you have been booked and have showed up, gone to trouble to show up, and nobody tells you, and you get there and you find out, oh, we canceled that 3 days ago, or something like that. I guess that's the, again, I guess you got to decide as a business matter whether or not you want to make the lawyer that engaged you mad by sending him a invoice. Would he have to pay it? Likely not. I think all you'd accomplish would be making him mad or her mad. But you can always remember that in future. And I know several court reporters that seem to try to avoid that circumstance by maybe making a courtesy call, maybe the afternoon before, or something to say, okay, on my books I have such and such with you on such, is that still a go? And that seems to blunt that some. Yes? Well, as I read the rule that says that the transcript must be created or produced under the personal supervision, effort of the court reporter concerned, or both. What that means, I don't think it can mean anything but this. You got to go there, you got to take down what happened. From that, you may use, and I alluded to scopists or proofreaders or whatever it is, people that help you get the text onto a final form transcript. And I think you can use those people. I think you'd go broke if you didn't, probably. I don't know. But you can use those people. The key to this is, I think, is after you've used them and they've provided you with the benefit they provide you, and you have in front of you the final form transcript that you have read and that you are satisfied is in fact the transcript, the original transcript. It is then and only then that I think you are complying with the law and being safe for your own protection, that you can affix your signed certificate or electronic signature, whatever it might be, or however you affix your signature and your license number to that final document. If you've not seen that final document, I mean seen the final document, I think you have not lived up to what the board rule requires. I think if you send off a certificate already signed in advance by you to be affixed to something that purports to be your work without having seen that work, I don't think you've complied with the law, and I think you are traveling on dangerous, dangerous ground. All right, one last thing. I have heard, although I don't know it, and I certainly do not want to get on the wrong side of any trial judge in the entire state of Tennessee or Georgia. Would not behoove me to do so. But I have heard that there is a practice in some counties in civil trials where a chancellor or circuit judge is pronouncing a rule that, well, there's no reason to have a court reporter personally here. We're recording this by video cam or whatever the courtroom system is that is there, and I don't know who that court is. I don't know anything about that. But I will tell you that if you want to take a look or have any attorney that wants to actually have a live court reporter present at a hearing or trial in the state of Tennessee before a court of record, TCA 20-9-101 gives an absolute right to the party that wants a live court reporter there. I'm not trying to tweak anybody's nose or any kind of thing like that, but I believe that statute would allow a lawyer, if he were brave enough to call the judge's hand, whatever judge is doing that. I just think that code section addresses it. And I hope I never have to do it, but I got a case or two pending up around through here. I don't know, I might. But anyway, I thank all of you for your time. Yes, ma'am.
Under that, what you just gave,
Yes.
say, who is the record then?
Well, let me read it to you.
No, I mean, what would be the official record then?
I don't think there's any question, but the record would be the record made by the stenographer, whoever was there taking it down. What?
Would it override a video?
All I can do is read you the statute, which I'll be glad to do if you give me a minute to find it. Well, of course, it would not be right where I thought it was going to be. Here it is. I'm reading to you from the Tennessee Code Annotated, Section 20-9-101, providing as follows. Upon the trial of any cause or proceeding in any court of record, upon the request of either party, the judge of such court shall appoint a competent court reporter who shall be first duly sworn to make a true, impartial, and complete stenographic report of all the oral testimony given in trial of the cause or proceeding, as well as the rulings of the trial judge. Now, ladies and gentlemen, if that doesn't cover it, I don't know what does. 20-9-101. Thank you.